Morning, gentlemen. Welcome to another tremendous day of online learning. So today's lesson is going to kick off by reviewing the task set in yesterday's or last lesson's class, and that being task 14 from page 22 of the workbook. So if you can get your work from last lesson in front of you, and we'll do a bit of self-assessment. So you're asked to consider 3 different scenarios from A to C and opine whether or not an unfair practice has occurred. So our roofing company, who ran a competition whereby they represented the prize as being a mini electric hatch vehicle, this is indeed an unfair practice because it was a misrepresentation of that prize because they did not intend to supply the actual vehicle. Instead, consumers were misled over the prize, which was a toy, which is not what reasonable consumers would have perceived or understood from the image of the mini electric hatch vehicle that was in the competition. So certainly an unfair practice there, guys, because we've lured in customers to our business thinking that they were going to be entrance into a competition that was worthwhile. Unfortunately, it's turned out that the competition isn't really worthwhile for consumers because they would have been in the chance to win a toy and not the actual mini electric hatch vehicle that they would have thought. So the business wins with more sales, but our consumers definitely lose confidence. Helping Me Limited has engaged in an unfair practice by running a pyramid selling scheme. And we can see this by Sid needing to pay the business for some coaching resources to join the business's team. So we've got a worker here paying to join the business, which is a bit of a telltale sign that we might have a pyramid selling scheme. Furthermore, the owner, Tui, has informed Sid that he will make his money back quickly, not by selling the products and the coaching to consumers, but by recruiting new coaches. So a legal business would have likely seen the owner referring to selling the products as a way to make money, but we've got here a pyramid selling scheme, which is shown by the owner saying to Sid that he'll make his money back by recruiting more members. So by Sid needing to pay money to join the business and that he earns money from recruiting new members are telltale signs that an unfair practice is operating, and that's a pyramid selling scheme. Finally, to consider Lean Meat Limited situation. So Lean Meat Limited has engaged in an unfair practice by using bait advertising regarding the ribeye steak. This is because the ribeye steak was sold out at 10 a.m. on Monday morning, despite being a weekly special. So the price of the ribeye steak was very, very attractive, and it's obviously going to result in a huge amount of demand from consumers who expect that this product is going to be available throughout the week because it's a weekly special. So the business has not provided a reasonable quantity of the ribeye steak at that promotional pricing, at the sale price. So by running this special, Lean Meat Limited is benefiting by luring in customers to their store to go and buy some kai. But sadly, customers who turn up from 10 a.m. on Monday morning throughout the week are not going to have any of the ribeye steak available. So that special is being used as bait to lure in consumers, but there's not a reasonable quantity of that product available. So here we've got bait advertising and certainly an unfair practice. Well, that's the formal conclusion of the Fair Trading Act content, reviewing that last activity there, and we're diving back into our introduction on contract law. So last lesson we had a look at contracts as a legally binding agreement between two or more parties, and it's legally binding because parties can go to court to get the court or a judge to enforce that duties and rights are carried out and respected. But for there to be a legally enforceable contract and valid, there must be 6 elements. And we looked at these last lesson. That contract must be serious and commercial, so just not a casual promise or a joking commitment amongst friends or siblings. Offer and acceptance of the contract's terms must be present, so people must actually agree to enter into the rights and duties of a legally enforceable contract. You can't accidentally contract here. You've got to be willing and intending to enter into their legally binding agreement. Exchange must occur. So we're talking about the exchange of value between parties, which we can call consideration as the technical term. In last lesson, we looked at that example of an employment contract. A worker is exchanging their labor, which is valuable, in return for receiving wages from the business. From the business perspective, they're exchanging wages, so money or value, and they're getting labor in return. Fourthly, people must have capacity, so the mental capacity or ability to understand the contract. So you have to have a certain amount of understanding and mental ability to be able to enter into a contract, because you've got to be able to understand the rights and responsibilities of a contract. So people who are particularly young or intoxicated or have a disability or an injury that prevents them from understanding the rights and responsibilities of a contract is likely to mean that they're unable to enter into a contract. Consent must be freely given. Absolutely, you cannot force someone to enter into a contract based on a threat or some kind of manipulation. We want people to freely enter contracts and be willing to carry out the rights and responsibilities. And finally, the activity must be legal. Contract law is simply not going to support illegal agreements between parties. So you can't have a contract over potentially selling drugs or a hitman murder for hire contract and expect to be able to go to court and enforce that that contract is carried out. That would be simply ridiculous. So let's have a look at serious and commercial in a little bit greater depth here, guys. So a contract can only be for serious and commercial purchases. A classic example is selling a house, hiring an employee, or purchasing a product. So all of these things here require consideration from the parties because there are rights and responsibilities associated with these activities. So this element of a valid contract prevents casual or joking commitments from being given legal status. So a little example there is if your sister promises to cut your hair if you mow the family lawns, and then as a true grammar man you go out and you mow the lawns, but your sister decided not to cut your hair, the court would not force her to do so. So this would be considered a bit of a casual commitment amongst people and not meeting that requirement of being serious and commercial. So this prevents the law from being drawn into squabbles or disagreements between friends and whānau, and it prevents that court from getting clogged up, getting distracted by these silly or non-consequential personal disagreements. So courts are very expensive to run. They require the time of highly qualified individuals such as judges, and we don't want that precious time being drawn into such disagreements. And moving to consider offer and acceptance in a little bit more detail here. So all parties must agree to the terms of the contract. So we can look at it like the terms of the contract. So what's to be done under the contract, what's required to be done, and who receives what. So those terms are offered or presented to the parties, and then all parties accept those terms. They accept the rights and duties contained in the contract. So offer and acceptance can be done verbally by actions, what we actually do, so non-verbal actions, and also in writing. An example of a offer and acceptance occurring without anything being said is when we go out shopping. Although, of course, we would want to be greeting our store people, and that's absolutely to do with our Auckland Grammar value of respect. It is possible to go into a store and pick up a bag of chips, maybe little Kettle original sea salt chips, place them on the counter of the store, put the money that covers the purchase price. The store owner can take your money, you take the chips with nothing being said, but a contract of sale has been entered into. So by those actions of picking up the chips, passing the money, and then taking the chips with you, your actions represent offer and acceptance of the contract to purchase the good. So while contracts do not need to be in writing, as evidenced by our chip purchase there, if there is a dispute, if there's a disagreement regarding a contract, it's much easier to prove and solve the issue if it's documented in writing. And our final slide of content today, just to look at exchange of value or consideration with a bit more depth here, is that so people in a contract, so parties to a contract, must be exchanging something of value with each other. Got our worker example there, labour is exchanged for income, and consumer exchanges money for products. If you're purchasing a house, you're exchanging the purchase price of money with the title of the house. This technical term for exchange value is consideration. So in consideration of the deal, I am going to give you X. So that's a technical term that we'd encourage you to use in your writing and explanations of this. So exchange is why simple promises to do something are not contracts. So many people give an undertaking to do something, so i.e. they promise to do something, but if there's no exchange, if there's no benefit received by the promiser, then it's not a contract. So if you help, I've got an example here, you promise to help a friend decorate his new restaurant, and your friend hasn't promised you something in exchange. Your friend hasn't said, oh great, I will pay you $20 an hour, and you both agree that that's acceptable. Then without such an exchange of value to the person who's promised to help, it's simply not legally enforceable. So this valid element of a contract is key for differentiating simple promises to help that people can give without much consideration, without much thought. It prevents those promises and undertakings from being given legal status. If it was the case that no consideration or exchange of value was needed, then our courts would be incredibly busy by being drawn into situations where someone has simply not done what they've been asked to do. And there are obviously situations where someone might promise to do something without much forethought or thinking about the consequences or their week ahead. And then it comes to pass that they just cannot do what they've promised, and they decide to do something else, that the court would be drawn into such situations, which would obviously take a lot of time because it's not uncommon that people promise to do things but then get distracted otherwise. Today's activities, guys, is to complete task 15 on page 25 and task 16 on page 26. Kia kaha.